Hello and welcome to the Kenneth Vercammen Law is Legal podcast. This week we look at workplace injuries and workers' compensation. Now, when the workers' compensation law was passed many years ago, it was probably the first type of what's called no-fault law that was passed. No fault meaning that you didn't have to prove that who was at fault for the accident under the law, with narrow exceptions. The question of negligence is not an issue if a worker is hurt on the job. Now, if someone is drunk or screwing around, then that could be a bar. But other than that, whether or not the employer is at fault, it has no impact on the worth of the case. So in workers' compensation, employees can bring a claim petition against their workers' compensation carrier. However, the employees cannot file a formal lawsuit against their employer for these types of injuries. Financial recovery is limited by the state law and workers' compensation cases. So if the injury is caused by the negligence of someone else other than the employer, then we can file a civil lawsuit in Superior Court. But in lawsuits, negligence must be proved against someone other than the employer. So it's the duty of the owner to make sure that that there's no problems. But jury trials are not permitted in workers' compensation cases. So generally, the issue is partial permanent disability. It's resolved by the attorney filing a claim in the Division of Workers' Compensation. An attorney who represents a claimant before the Division of Compensation may not charge a fee in advance. The workers' compensation judge who hears the case will set a fee, never more than 20%, and if there's no recovery, the lawyer will not be allowed a fee. So if someone's injured on the job and it's a bad enough injury, you want to timely bring a claim. For more information on workers' compensation cases, visit website njlaws.com, and for representation, contact Kenneth Vercammen's office at 732-572-0500.